Okay, so I got this Bureau of Labor letter. Brandon Reeves, who investigated the Multnomah District Attorney for gender discrimination, called me, possibly to just kind of keep me grounded in this is mostly good. But of course, what it does is it has Ozark Iraq's retaliatory false allegations in his defense. Okay, so I'm just gonna read the whole thing to you guys. All right. Mary Yang, November 3rd. Civil Rights Division has concluded the investigation and review of the above cited case and determined there is substantial evidence to support the allegations of discrimination. The division may refer this matter to the Administrative Prosecution Unit for contested case hearing consideration and may facilitate an attempt to reach a reasonable settlement of this matter. Please see the enclosure with information on the conciliation process. However, no action is required from you at this time. You have the right to withdraw this case at any time. Please see ORS 659A.1875 regarding the time limitations that apply to any right you may have to file a civil action in circuit court. Note, pursuant to ORS 192.5018, the Bureau cannot release a copy of the file until it is closed. The above case is not yet closed. Please take note of any enclosures sent with this letter. Sincerely, Civil Rights Division, Administrative Support Unit. Okay, so I could read this conciliation process, but I'll pass for a second. Let's get to the juicy one, because that's just sort of like bureaucraties of how the process works. Okay, look at that. Okay, so Civil Rights Division, Bureau of Labor and Industries, Notice of Substantial Evidence Determination, date issued November 3rd, 2023, Civil Rights Division. Complainant Mary Ang, respondent Lifeboat Services, DBA, doing business as Beacon Clubhouse. Case number STPADP230104-176. Investigator Brandon Reeves. Filing date, January 4, 2023. Reviewed by Chris Lynch, and that's like a lead attorney or lead investigator at Foley. I've talked to him before. Jurisdiction. Oregon Revised Statutes. Oh my gosh, this is a lot. Chapters 659A or ORS 25.337, 424, 171.120, 345.240, 441.184, 476.576, 651.061, 651.120, 652.355, 653.060, and 654.062, and Oregon Administrative Rules, Chapter 839, Divisions 2, 3, 4, 5, 6, 9, and 10, authorize the Civil Rights Division to accept, investigate, amend, resolve, and determine complaints alleging unlawful practices in employment, housing, places of public accommodation, state government, and career, professional, and trade schools. Specific facts supporting a conclusion that the division has jurisdiction over respondents are found below. Synopsis. Okay, this is Roman numeral 2. Complainant alleges that respondent discriminated against her based on her disability status. Specifically, complainant alleges respondent excluded her from its facilities and services because of her disability status. Respondent denies maintaining its actions against complainant non-discriminatory. As will be discussed below, Boley finds there is substantial evidence to support complainant's claim. Footnote 1, substantial evidence means proof that a reasonable person would accept as sufficient to support the allegations of the complaint. And that's OAR, Oregon Administrative Rules 839-00-0005, parentheses 15, section A. Okay, the Roman numeral 3, brief summary. In February 2021, complaint was referred by a private mental health professional to the respondent, who subsequently enrolled her in its non-clinical mental health program. In February 2022, complainant claimed she was aggressively confronted by respondent's director, Ozark Iraq, over the organization's donation policy. She describes being physically cornered, shouted at, and intimidated, actions which she believes aggravated her existing mental health conditions. Respondent, however, denies this portrayal, presenting evidence suggesting Iraq approached the complainant calmly. On May 19th, 2022, complainant relayed her encounter with ORAC in an email to respondent's administrator, Erin Carlson. In this communication, she also highlighted other alleged incidents of illegal, discriminatory, and intimidating behavior she either witnessed or personally endured at respondents' facilities, underscoring the negative toll these events took on her mental health. Upon receiving complainant's email, Carlson promptly responded, recognizing complainant's concerns. In her email, she sought to clarify any misunderstandings and proposed preliminary solutions, noting that Carlson admired complainant's passion and always enjoyed her intelligent and thought-provoking conversations. Concurrently and contrastingly, ORAC, after reviewing complainant's email, drafted an incident report. In this report, he described complainant's account as disjointed and speculated that she might have been under the influence or experiencing mental instability when she wrote the email. See excerpt from ORAC's May 19th incident report below. Erin received an email from Mary Ang exposing previous communications with Clubhouse International and admin breaching confidentiality of sensitive, misspelled, sick, member info, falsely accusing staff of various things and incoherently describing events that occurred off-site with people. She appeared to be high or out of her mind. Clubhouse International informed Erin that she had been calling and emailing with strange narratives about Executive Director ORAC. As a noted resolution in his report, ORAC barred complainant from accessing respondents' premises. 4. Analysis. Oregon law prohibits public accommodations from discriminating on the basis of disability. In this case, there's evidence suggesting that respondent denied complainant access to its facilities, at least partially due to her disability. This is underscored by the immediate ban on complainant from using respondent services a day after she submitted an email complaint to respondent accusing it of abuse, neglect, and other forms of unlawful behavior. However, respondent contends that it barred complainant because she was a threat to its community. Specifically, in response to complainant's discrimination charge, respondent alleges that complainant bullied disabled members, recorded and uploaded videos without permission, misused Social Security funds of disabled individuals, plural, and made racially insensitive remarks. Additionally, respondent was concerned about the way complainant lodged her complaints, noting she communicated with external parties, allegedly relaying false or misleading information. Respondent also implies that complainant's actions might be the result of an earlier disagreement with ORAC regarding respondent's donation practices. Complainant, however, denies these allegations. Despite respondent's arguments, there are elements that support complainant's claim of discrimination. Most prominently, her concern about unfair treatment were quickly dismissed without thorough inquiry, leading to an immediate ban on the day she submitted her complaint. Moreover, ORAC's characterization of complainant in her email as seeming high or out of her mind can reasonably be viewed as remarks about her mental well-being. If a respondent presents substantial evidence that a legitimate, non-discriminatory reason contributed to its actions, but Boley finds that complainant's protected class membership was also a motivating factor in the respondent's action, then there is substantial evidence of discrimination. Here, while some of the respondent's reasons for excluding the complainant might be valid, Boley concludes the complainant's disability status also factored into the decision. Determination. The Bureau of Labor and Industry Civil Rights Division finds substantial evidence of an unlawful employment practice on basis of disability status in that respondent excluded complainant from its facilities and services because of her disability status in violation of ORS 659A.142, Brandon Reeves, Senior Investigator, Civil Rights Division. Okay, so I'm glad I got that into the record. And I really don't know why they're not sending me digital. I mean, it's great to have paper, but why not digital too? Because I was going to immediately send this to the newspaper, right? And then I didn't read it as carefully last night as I just read it, and I was kind of taken aback because he's literally throwing my accusations right back at him. I complained about neo-Nazi verbiage, anti-Black verbiage, his bullying of a Latino person, a Black person being pushed down the staircase, and then he's turning it back and calling me the racist. Okay. So, oh boy, that's like not okay with me. And then in terms of saying I'm misusing Social Security funds of disabled individuals, that is really strong complaint, because that's actually what I've complained, is that the disabled people going to his facility are repeatedly solicited to buy drugs and to provide their money to the homeless panhandlers on the block at Lifeboat. So it's like, that's my concern. And then he's like, no, you're misusing Social Security, or no, you're the racist. He doesn't care. There's like 5 people down there right now who use the N-word and have used it abundantly at his facility. I have never done anything like that. And then he's calling me the racist for pointing that out, or calling me the racist for pointing out anti-Semitism. Okay. Oh boy. But this is Ozark, Iraq, guys. You know the one. He's really ruthless, and my theory is his level of ruthlessness. Well, like for instance, okay, if I have, if he really wanted to put me on trial for this, I have credit card records proving that I have paid disabled people's internet bill for over a year and a half, or I have check stubs proving that I've paid their rent. I have paid people's water bill. I don't stand up on a pedestal saying, look at me, look at all the great things I've done. But if you want to start accusing me of some kind of financial abuse, that is just, it's really the opposite. And his lack of empathy for the type of, it's shocking. But there we go, guys. So as with bureaucracy, it looks like we could just wait another probably 1,000 years before some other report gets issued. But here, let's read about the conciliation process. Okay, this is the flyer I skipped. Information for complainants receiving a determination of substantial evidence of an unlawful practice or unlawful employment practice. Conciliation process. The investigation of this case has resulted in a determination of substantial evidence that an unlawful practice or unlawful employment practice occurred. The division may facilitate settlement negotiations between the complainant and the respondent, refer the matter directly to the contested case hearing, or administratively close the case. The complainant and respondent have the right to decline to enter into settlement negotiation or to reject any settlement offer made. However, if complainant declines or otherwise fails to participate in the conciliation process or rejects the settlement offer made by respondent that the division considers to provide full remedy, the case may be administratively closed. Complainant has the right to withdraw the complaint from the division at any time, pursue the matter by filing a civil action in civil court, subject to statutory deadlines set forth in ORS 659A.875. Boley facilitated conciliation agreements are voluntary no-fault settlements. Conciliation agreements may provide for remedies to a complainant, including but not limited to monetary payment for lost wages and pain and suffering, as well as employment or reinstatement of employment. If complainant and respondent agree to settle the case, the division prepares a conciliation agreement for complainant, respondent, and the division to sign. Well, for instance, retract your false allegations, Ozark, okay? When the conciliation agreement is signed by all parties, the case is closed. If complainant settles the case, complainant does not have the right to file a civil suit in court on the same issues. Interesting. Complainant's options if conciliation fails. If conciliation fails, a division supervisor reviews the case to determine whether it is appropriate for a contested case hearing in Boley's administrative prosecution unit. If it is not, the division will inform complainant and close the file. If a notice of complainant's right to file a civil action in circuit court has not previously been issued, it will be issued at the time of the case closure. If the division determines the case is appropriate for a contested case hearing, it is forwarded to the administrative prosecution unit, where an administrative prosecutor reviews the case to determine if it is likely to prevail in a hearing. If the prosecutor finds it is not likely to prevail in a hearing, the prosecutor will so inform complainant and close the file. If a notice of complainant's right to file a civil action in circuit court has not previously been issued, it will be issued at the time of the case closure. If the administrative prosecutor determines that the case is likely to prevail in a hearing, the prosecutor will so inform complainant and will serve specific charges on respondent. The prosecutor will represent the case in a contested case hearing. Complainants do not need an attorney to participate in a contested case hearing. If wishing to consult with an attorney, you may contact Oregon State Bar Referral. Okay, the Bureau is not allowed to make referrals. So Brandon was literally like, this is good. And I was like, well, is this the end of your leg of the journey? And he's like, yeah, because basically he's passing it to another section of the bureaucracy. I was going to go down to city council, but I literally got this like 30 minutes before city council started, and it's really kind of good I didn't go to city council because I really needed to read it, especially to talk about this. Okay, so it's like part of the game. Ozark called the police October 27th to have me preemptively kicked out of the defunct non-open shelter where the stabbing occurred in February 2023. Why? I'm piecing it together. It appears Alex Thomas over at the Clatsop District Attorney's Office called him and said, hey, dude, we're dropping your retaliation case against her. I like it that they don't mention the retaliation case because it was obviously fictitious. And I like it that they issued after that case got dropped. I think they might have been waiting for that because they fully expected it to be dropped eventually. So I think it triggered this being delivered, like it was ready to go. I expected it might come as late as January, so I'm kind of glad to have it. And guys, go to Lifeboat at your own risk. You may be subjected to violent crime, sexual assault, bullying. This really doesn't even go into the meat and bones of how much bullying, abuse, verbal abuse, sexist abuse, and furthermore, Brandon was letting me know all the other people that you've tried to be like a class rep for and like, state their claim and state all the abuse they get from Ozark or his clients. Those are not included in your report. This is very narrowly tailored into your claim. And I understood that about the administrative procedure, but it doesn't mean that all these other people who've been bullied or suffered abuse or discrimination don't have valid claims. And he highly encourages them to participate in this wonderful, exhaustive, like 18-month process or however long this is going to drag out, which the administrative burden of the paperwork, the signatures, the interviews, is a huge burden on people who don't have the time, the energy, the housing, the internet connection, the phone connection, etc. So in a way, I'm doing this on their behalf.